Hello students and welcome to the lecture. So students, as we know that we are covering the directive principles of the state policy, all right? And basically these are the topics which we have scheduled for the discussion under this particular series. Like starting with the introduction part, thereafter the features of the directive principles, thereafter the classification of directive principles, new directive principles, connection behind the directive principles, criticism of the directive principles, all right? Utility of directive principles, conflict between fundamental rights and the directive principles, distinct between fundamental rights and the directive principles, implementation of directive principles outside part 4, and the articles related to directive principles of state policy at a glance. All right, this is the topics which we have scheduled for the discussion. Out of these, basically, we had finished the introduction part, features of the directive principles, classification of directive principles, new directive principles, connection behind directive principles, criticism of the directive principles, utility of directive principles is the topic which we have been discussing. All right. And the topics we are left with are the conflict between fundamental rights and directive principles, distinction between fundamental rights and directive principles, implementation of directive principles, directives outside part 4, articles related to the directive principles of state policy at a glance. So we will start from where we had left in the previous lecture. All right. So basically, we were discussing the utility of directive principles. So here is another one. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directive principle. So basically, we know that when we talk about the democracy, right? Whenever we talk about the democracy, then we know that democracy is having the concept of which? Concept of limited government, right? Democracy basically having the concept of limited government. All right. Why? Because in democracy, basically there are two types. Basically, there are two types. First type is ruling government. Second is the opposition, right? Got it? So basically, what happens in the democracy that we know that there is a system of voting, right? People generally vote in the elections, and elections various you can say political party contest with each other, and the party which will secure the maximum votes will have the government at the center, right? And the other parties will form the opposition. All right. So that's why there is a limited government. Why? Because the ruling party is responsible for the people who have selected it, and even the ruling party has to do work in accordance with the opposition. Why? Because the opposition can target the ruling party into the next election. All right. So basically, the directive principles are basically useful for the opposition so that they could exercise their influence and control over the operations of the government. How? Basically, the opposition could blame the ruling party that whatever the activities is ruling party is doing are basically against the directives. Why? Because as we has discussed that these directives are basically having the welfare approach, all right, and basically having two things. And what are these two things? First is social freedom and economic freedom. Also, we could call it as a democracy. All right. So that's why it is necessary that the government, or you can say the ruling party, whichsoever in the center, is required to use these directives to make the rules and the regulations for the implementation. All right, that is the another point that we have just discussed. Next point is they serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declarations. All right, like whatsoever the government has did, you could say that basically the fundamental rights provided the political democracy, right? So nothing has to be done for them. Why? Because these are already protected by the constitution. But what about the social democracy and the economic democracy or the freedom? Basically, the ruling party or the government, which is in the center or in the power, is basically responsible to make the rules and regulations and to perform the acts as per the provisions of this social freedom and the economic freedom. All right. So that the people could be benefited. All right. So that's why this is a crucial performance test of the government. Like whatever the steps the government had taken in respect of these, that will define that how useful is the government for the constitution. Got it? That's the thing. All right. They serve as a common political manifesto. Why? A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend in its legislative and executive acts. All right. Like these articles basically provided the guidance that what step they are required to be taken. All right. What things they should do. All right. And how they should manage the things. Then only they will be able to do the, you can say, required legislative acts and the executive acts. All right. So these are the points. And this defines the utility of the directive principles. All right. And here we could also say that, however, these are non-justicable in nature and non-enforceable. Why? Because these acts are basically, you could say, not having any legal mandate. But still, they could be enforced by the people, by the opposition, and even the ruling party indulge these things in its activities so that they could secure the maximum performance right. All right. Thereafter, another topic which we have is the conflict between the fundamental rights and the directive principle. The justicability of fundamental rights and non-justicability of the directive principles on one hand, and the moral obligation of the state to implement directive principles, Article 37, on the other hand, have led to the conflict between the two since the commencement of the Constitution. So, what we have seen, that basically we see that whenever we talk about the democracy, all right. So basically, in India, even the preamble of the Constitution, we had signified the aspirations, what we want to be, and we define the democracy in three terms, like the political democracy, all right, like the social democracy, and the last is economical democracy or economic democracy. Political democracy, social democracy, and the economic democracy. All right. These are the three types of democracies we talk about. And we know that the political democracy is basically secured and the restored by the fundamental rights. All right. And the social and economic democracy is basically secured by the Directive, principles of state policy. Right? That is the thing. But here is a one thing. What? That the fundamental rights, which are one of the pillars of the democracy, is justicable and enforceable. Whereas the directive principles, which are the another pair of the, you can say, the democracy, another pillar of the democracy, they are non justicable. All right. However, basically, we have provided the Article 37 in the Constitution, which says that the directive principles must be implemented, but not on the legal obligation as per the fundamental rights. All right. But on the basis of the moral obligation. And this is basically, you can say, this is the conflict between the two since the commencement of the Constitution. On which date the Constitution was commencement? All right. Now here is a revision test for you all. All right. 9 December 1946. 13 December 1946. 24th November 1949. 26th November 1949. 24th January 1950. 26th January 1950. All right. Now these are the dates which I have put in front of you. And now you are required to remember that what happened on these dates. All right. I am providing you the time period of 30 seconds. Then I will give you the answer. Just look at the dates, take your time, and try to fill the correct answer. And your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically, on 9 December 1946, there was a first meeting of Constituent Assembly. All right, for the first time they met. On 13 December 1946, the objectives and resolutions were presented. On 24th November 1949, Constitution was prepared. On 26th November 1949, Constitution was revised. On 24th January 1950, Constitution was signed. All right. And 26th January 1950, Constitution was implemented or commenced. All right. So basically, this is the you can say the timeline, and this is very very important from the examination point of view. Remember, not timeline. Let me write down again. Important dates or timelines in making of the Constitution. Got it? So keep this thing in your mind. All right. In the Chankapan Durai Rajan case, which was happened in 1951, just after another year of the commencement of the Constitution, because our Constitution was commenced on 26 January 1950, as I told. The Supreme Court ruled that in any case of conflict between the fundamental rights and the directive principles, the former would prevail. Like you could say, suppose if the government had passed the judgment over anything, or you can say not judgment, basically, if the government had formatted the legislature on anything on it, and this legislature basically generates the conflict between the fundamental rights and directive principle of state policy, not fundamental duties. Directive principles of state policy. Okay, because of the legislature which had been passed by the government, suppose there is a condition occurred in which the political freedom and the social economic freedom are collapsing with each other, and there is a stage of conflict between them. In such kind of situation, what will happen? That always the fundamental rights will give the fundamental rights will have the upper hand. All right. So that provision had been provided by the Supreme Court in the famous case of Changapan Dorirajan 1951. All right. Why? Because the fundamental rights are legally implemented, whereas the directive principles of state policy are morally obligated. Okay. It declared that the directive principles have to conform to and run as a subsidiary to the fundamental rights. It means that the weightage of fundamental rights will always be superior than the weightage of directive principles. All right. But it also held that the fundamental rights could be amended by the parliament by enacting constitutional amendment acts. As a result, the parliament first made the amendment in 1951. This is another question. Like if in the examination, the question will be asked to you, like which was the first amendment and in which year it was passed. Always remember, the First Amendment Act was passed in the year of 1951. Thereafter, the Fourth Amendment, which was passed in the year of 1955, and the 17th Amendment Act, which was passed in the year of 1964 to implement some of the directives. The above situation underwent a major changes in 1967 following the Supreme Court judgment in the Golaknath case 1967. So what happens that, however, in the Changappan Doirajan case 1951, Supreme Court said that if any conflict arises between the provisions of the fundamental rights and the directive principles, so the weightage of fundamental rights will always be higher than the directive principles. But they also said, like, if the government want, then the government could make the changes in the provisions of the fundamental rights, then the directive principles could be implemented smoothly. All right. And for this, various amendments and various changes have been made in the quick succession of the years, like 1951, 1955, and the 1964. Please remember the amendment, like First Amendment, Fourth Amendment, and the 17th Amendment. All right. And the situation even went major changes in the 1967 when the Golaknath case was implemented. Got it? In that case, Supreme Court ruled out that the Parliament cannot take away or abridge any fundamental rights which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of directive principle. So what happened? Like, however, in the 1951 case, Supreme Court said that, however, the fundamental rights are legally obligated while the directive principles are morally obligated, which means the fundamental rights will have the upper hand in case of both. All right. But they even said if government want to make some changes, then the government could do it by the amendments. And the situation reversed in the case of 1967 when the case was about the Golaknath. In this case, the Supreme Court stated that, however, the powers has been granted to the government or the parliament to make the changes into the fundamental rights to implement the provisions side by side. But the fundamental rights could not be amended for the implementations of directive principles. All right. It means that only the provisions could be made so that they both could be implemented side by side. All right. But situation could not be made in a situation when the fundamental rights will have to be done follow in comparison with the DPSP or the directive principle of state policy. All right. Thereafter, the parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971 and 25th Amendment Act 1970. Remember, both the amendments were as in the reaction against the Golaknath case, or you can say in response of the Golaknath case. Do not use the word against. All right. But both acts were passed in the same year of 1971. That is important. 24th Amendment Act declared that the Parliament has the power to abridge or take away any fundamental rights by enacting the Constitutional Amendment Acts. Okay. And 25 Act inserted a new Article 31C which contained the following two provisions. All right. So what happened? Like the Supreme Court said, the Parliament could not abridge or take away any fundamental rights in response of implementing any DPSP. But the Parliament said that we have made an amendment through the 24th Amendment Act. And basically this amendment empowers the Parliament to abridge or take away any fundamental rights by enacting the any Constitutional Amendment Act. All right. Thereafter, 25th Amendment Act inserted a new Article 31C which having the two following provisions. Let's see. No law which seek to implement the socialistic directive principles specified in 39B, 22 and 23 shall be void on the grounds of contravention of the fundamental rights conferred by the Article 40, which states the equality before law and equal protection of laws. Whereas the Article 90, which states the protection of 6 rights in respect of speech, assembly, movement, etc., or Article 31, right to property. That is the first provision. Second provision was, no law containing a declaration for giving effect to such policy shall be cautioned in any court on the ground that it does not give effect to such policy. All right. So basically, the parliament said that there is no requirement to pass any legislature or law for the implementation of these acts. And this is basically powered by the newly inserted article, Article 31C, which was inserted from the amendment of 25th Amendment Act 1971. Got it? In the Keshavnanda Bharti case, which is very famous case, 1973, the Supreme Court declared the above second provision of 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above provision of 31C was held to be constitutional and valid. It means 31C stated two provisions. The first one was passed and the second one was declared unconstitutional and void. All right. So students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise all the facts and figures which we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.